This video is a creative representation based on the public transcript of the Memorandum and Order Re. 49, motion to dismiss regarding the case of SEC v. Richard J. Schueler, a.k.a. Richard Hart, Hex, PulseChain and PulseX. Defendant's motion to dismiss is granted. Plaintiff's request for leave to amend is granted. An extension of time to amend is granted. Any such amended complaint must be filed by April 21, 2025. All visuals, audio, and character representations in this video are purely for illustrative and entertainment purposes, and not intended to depict them exactly as they occurred. This video is not an official record and should not be relied upon as an exact factual nor legally viable representation of events. The information presented is derived from publicly available sources, including the Memorandum and Order, which you can find in the link in the description beneath this video. While we strive for accuracy, we do not guarantee complete accuracy and are not liable for any potential misinterpretations or misunderstandings. Viewer discretion is advised. United States District Court, Eastern District of New York on Securities and Exchange Commission, Plaintiff. Against Richard J. Schueler, a.k.a. Richard Hart, Hex, PulseChain and PulseX, Defendants. Amon, United States District Judge. Introduction.
Plaintiff Securities and Exchange Commission, SEC, brought this action against defendants Richard J. Schueler, a.k.a. Richard Hart, Hex, PulseChain and PulseX. The SEC failed to respond to Hart's challenge to the SEC's purported alter ego theory regarding Hex, PulseChain, and PulseX. At oral argument, the SEC conceded that it failed to respond to this argument and that the alter ego claims were not part of its theory for why the court would have personal jurisdiction. I therefore find that the SEC chose to abandon any arguments it could have made regarding the alleged alter ego entities. See Maher v. All Mortgage Banking Corp., Lipton v. County of Orange. This court may, and generally will, deem a claim abandoned when a plaintiff fails to respond to a defendant's arguments that the claim should be dismissed. The SEC alleges that Hart violated the Securities Act of 1933, Securities Act, and the Securities Exchange Act of 1934, Exchange Act, by promoting, offering, and selling unregistered crypto asset securities and defrauding investors by misappropriating investor funds. Pursuant to Rules 12b-2 and 12b-6 of the Federal Rules of Civil Procedure, Hart moves to dismiss all claims both for lack of personal jurisdiction and for failure to state a claim. For the reasons stated below, the motion to dismiss is granted.
Background.
The following facts are taken from the complaint and are assumed true for purposes of this motion. I draw all reasonable inferences in the SEC's favor. See Buon v. Spindler. I also rely, as appropriate, on certain of the exhibits attached to the declaration of Derek Kleinman, including a transcript from the PulseChain conference in Las Vegas, Nevada in September 2022, and the declaration of Kyle Barr. Hart is a United States citizen currently residing in Finland. He is the founder of Hex, PulseChain, and PulseX, each alleged to be a crypto asset security, collectively Hart's crypto assets. Crypto assets, which are also called cryptocurrency or tokens, are decentralized digital commodities. In Re. Buybox Group Holdings Limited Security Litigation.
1. The offer periods. A. Hex.
From December 3, 2019 to November 19, 2020, Hart offered and sold Hex tokens to investors, some of whom resided in the United States, in exchange for ETH, Hex offer period. ETH is a unit of cryptocurrency that is the native token or digital asset of the Ethereum blockchain. SECV Telegram Group Inc. Hex is an ERC token, which is a technical standard that defines how fungible tokens operate on the Ethereum blockchain. Blockchains are decentralized digital ledgers that serve to validate transfers of cryptocurrency. Blockchains consist of blocks of data that track the ownership and transfer of crypto assets on a given network, dating back to the first ever transaction on that network. Risley versus Universal Navigation Incorporated. Hart designed Hex to operate on Ethereum as a smart contract. Smart contracts perform self-executing functions when predetermined conditions are met. The Hex offering and communications occurred globally through social media and Hart's websites. Hart allegedly operates and controls Hex.com, Hex.win, ETHhex.com, PulseChain.com, and PulseX.com. To facilitate the hex offering, Hart created several digital wallet addresses, which he allegedly owns and controls. Digital wallets, pieces of software akin to a bank account for digital assets, store private keys, which grant control over individual tokens and permit users to easily send and receive tokens via the blockchain. Telegram. Hart created a digital wallet address on the Ethereum blockchain known as the Hex contract address, HEX-CA, and a separate private wallet address known as the Hex Flush address, which was programmed directly into Hex's code before he sold any Hex tokens. Investors sent ETH to the Hex contract address and received Hex tokens in return. The ETH in the HEX-CA would then be automatically transferred, or flushed, to the Hex Flush address. According to the SEC, after investors' ETH transferred into the Hex Flush address, it was sent through a series of transactions, known as recycling, involving intermediary digital wallet addresses on crypto asset trading platforms, before eventually being sent back into the HEX-CA. The holders of the digital wallet addresses perpetuating the recycling transactions would receive additional HEX for each transaction. During its investigation, the SEC discovered that approximately 94 to 97% of the ETH deposited into the HEX-CA went through this recycling process. The SEC alleges that Hart created a false appearance of significant organic demand for HEX tokens, when in reality, the majority of these transactions were recycling transactions that let Hart gain control over a large number of HEX tokens. During the HEX offer period, Hart marketed and promoted HEX using several online and social media platforms, including Twitter, YouTube live streams, YouTube Live, and the Hex.com website. For example, Hart marketed Hex's staking feature, frequently referring to Hex as the first high-yield blockchain certificate of deposit on Ethereum. Staking allows investors to lock up their Hex tokens for a designated period in exchange for additional Hex tokens as a return on their investment. The Hex tokens would be sent to an ownerless address on the Ethereum blockchain. The locked-up tokens could not be transferred out until the smart contract recognized the necessary predetermined conditions. Hart likened staking to conventional interest payments, claiming that investors would receive an average investment return of 38%. Hart also explained that the staking protocol benefited everyone who held Hex tokens because when people lock up their Hex coins, that would cause the price to go up and the market cap to go down, allowing investors to keep building appreciations and mad gains. The complaint further alleges that Hart touted Hex's capacity for profitability, claiming to investors that if you want to get rich, Hex is built for that, and that Hex was designed to surpass ETH and become the highest appreciating asset that has ever existed in the history of man. It also recounts Hart's efforts to make Hex a success. Hart shared with potential investors how-to videos describing how investors could purchase and stake their Hex tokens. Hart promised investors he would personally call crypto asset trading platforms to get Hex listed. Hart sent private Twitter messages to a crypto asset trading platform, which subsequently listed Hex on its platform in December 2019. Hart further claimed to investors that almost all of his time was going towards developing the Hex ecosystem. 2 U.S. investors invested in Hex after learning about Hex through Hart's online activities. Hart also used incentives to attract investors. He promoted a rewards program called Big Payday that rewarded investors who staked their Hex tokens with bonus payments of unclaimed Hex tokens. Throughout the Hex offering, Hart allegedly distributed at least $1 billion worth of Hex tokens through this program. Hart also orchestrated 2 separate airdrops to generate additional investor interest in Hex. An airdrop is a distribution of crypto assets where the recipient receives crypto assets without providing cash consideration or taking any steps to accept. He identified significant holders of both Bitcoin and ETH and directed his developers to deposit Hex tokens into the holders' digital wallets. The alleged purpose of these airdrops was to increase market awareness for Hex. Ultimately, the Hex offering received at least 2,371,362 ETH deposits from 21,156 identifiable digital wallet addresses, including deposits from 10 U.S. investors.
B. PulseChain
From July 15, 2021 to August 3, 2021, Hart coordinated an offering to raise investor funds to allegedly develop PulseChain offer period. The SEC alleges that the PulseChain offer period was unofficially extended to April 6, 2022. PulseChain is a hard fork of the Ethereum blockchain with its own native token Pulse, PLS. A fork occurs when an existing blockchain, in this case Ethereum, is copied and then a new set of rules applies independent of the copied blockchain. See also Reina S. Hucke, Rodrigo Serra Silva Herzog, Brent A. Plummer, Nelson M. Rosario, Blockchain Development and Fiduciary Duty, 2, Stan. J. Blockchain L. and Pauli. A hard fork effectively allows any individual to copy the current publicly available source code of a certain public blockchain's software application, modify it to reflect a new rule set, re-release it to the public, and coalesce a community around the revised protocol. The primary purpose of PulseChain was to run faster and with cheaper gas fees than Ethereum. Gas fees are akin to a transaction fee that enables users to execute transactions on the network. PulseChain uses PLS as gas. To participate in the PulseChain offering, investors deposited or sacrificed crypto assets, including ETH, into a digital wallet address, PulseChain SA. In exchange, PulseChain investors ultimately received PLS tokens in May 2023 when PulseChain launched. During the PulseChain offer period, Hart promoted and marketed PulseChain through his websites and social media. For example, Hart touted the expected profits for potential PulseChain investors, claiming that 14,000 times is a reasonable estimate for what could be possible for Pulse. Hart also emphasized his efforts to develop PulseChain. On YouTube Live, Hart described his progress to get PulseChain ready for the launch. Ultimately, the PulseChain offering collected crypto asset deposits worth over $354 million, including deposits from at least 10 U.S. investors.
See PulseX.
From December 29, 2021 to February 26, 2022, Hart coordinated an offering to raise investor funds to allegedly develop PulseX offer period. The SEC alleges that the PulseX offer period, like the PulseChain offer period, was also unofficially extended to April 6, 2022. Hart developed PulseX and its native token PLSX around the same time as PulseChain. PulseX is a decentralized protocol on the Ethereum blockchain that acts as PulseChain's decentralized crypto asset trading platform through a fork of the Uniswap platform. According to the SEC, most secondary market transactions occur on Uniswap, a decentralized crypto asset trading platform. On Uniswap, users identify which tokens they want to trade and which tokens they want to receive, and then Uniswap swaps the identified tokens. See Risley, discussing how Uniswap executes token swaps. To participate in the PulseX offering, investors similarly deposited or sacrificed crypto assets to a PulseX digital wallet address, PulseX SA. In exchange, investors ultimately received PLSX in May 2023 when PulseX launched. During the PulseX offer period, Hart promoted and marketed PulseX through his websites and social media. Hart claimed PulseX was the coolest, highest liquidity automated market maker exchange, and that it was well within the realm of possibility that PLSX would appreciate around 10,000x in 2 years. According to the SEC, Hart tied the launch of PulseX and PulseChain to an increase in profits for investors in Hart's crypto assets. Hart explained that when an investor deposits HEX tokens during the PulseX offer period, hundreds of millions of dollars in HEX tokens are removed from the supply. With this reduced supply of HEX tokens in circulation, Hart claimed that HEX tokens would appreciate and be more valuable on Pulse than on Ethereum. Ultimately, the PulseX offering received crypto asset deposits worth over $676 million, including deposits from at least 10 U.S. investors.
2. Post-offer period statements. A. HEX.
After the HEX offer period, Hart continued to market and promote HEX to allegedly drive HEX's demand on the secondary market. HEX's websites published statements claiming that HEX appreciated faster than anything else and that HEX's primary design intention is price appreciation. Hart also directed potential investors to visit his website, Hex.com, which allowed investors to transact in secondary market purchases directly through Uniswap. Hart also made 2 virtual appearances before audiences in the United States. In the SEC's view, Hart continued to promote Hex, PulseChain, and PulseX during these appearances. Hart appeared at a conference known as Hex Conference in March 2022 and a conference known as PulseCon in September 2022. During these appearances, Hart touted Hex's giant volume on decentralized exchanges and that he wouldn't be surprised if at some point Hex started doing the same things that it used to do, which is just overperforming like crazy. On August 15, 2022, Hart also appeared in person for a live podcast interview in Miami, Florida, where he discussed Hex, PulseChain, and PulseX. Miami interview. Hart again bragged about Hex's performance, claiming Hex produced 10,000 X returns in 2 years.
B. PulseChain and PulseX.
After the PulseChain and PulseX offer periods, Hart continued to market and promote PulseChain and PulseX. He stated at PulseCon that his developers are geniuses. They find bugs other people don't. And that, before we launch, we want everything to be right. These statements are alleged to have led investors to believe that if Hart and his developers did not complete PulseChain's development, the value of their investment would collapse. Hart also stated that because PulseChain is gonna launch at 0, it's pretty hard to beat the ROI of something that goes from 0 to anything. It's like infinite ROI. Based on Hart's statements, one Brooklyn investor believed that his deposits were being used to develop PulseChain and that PLS tokens would increase in value. Regarding PulseX, Hart, through a Telegram chat, described how PulseX functioned to one potential U.S. investor. Hart provided the investor with step-by-step instructions on how to purchase crypto assets and how to transfer them to PulseChain and swap on PulseX. Further, on YouTube Live, when asked about an update on the launch of PulseChain and PulseX, Hart replied that it's done when it's done. Software is hard. The developers are working hard on it. That's all there is to it.
3. PulseChain fraud allegations.
The SEC further alleges that Hart defrauded PulseChain investors and engaged in deceptive conduct. From August 3, 2021 through September 22, 2022, the SEC alleges that Hart misappropriated $12.1 million of PulseChain investor deposits to purchase luxury items, including cars, watches, and diamonds. To disguise these transactions, PulseChain deposits were first transferred to Hart's private wallet and then transferred through a series of mixer transactions before ending up on 3 crypto asset platforms. Mixer transactions anonymize transactions by disguising the origin, destination, and parties involved. According to the complaint, these mixer transactions ultimately benefited Hart through his personal purchases. Hart never disclosed to investors that their deposits would be used to fund such purchases.
4. Complaints causes of action.
Based upon these allegations, the SEC asserts 2 basic claims for relief against Hart. First, it alleges that Hart violated Section 5 of the Securities Act by failing to register the offer and sale of Hart's crypto assets as required by the securities laws, unregistered securities claims. Second, it alleges that Hart violated the anti-fraud provisions of the federal securities laws with respect to the offer and sale of his crypto asset, PulseChain fraud claims.
1. Rule 12b2.
To defeat a motion to dismiss for lack of personal jurisdiction, the plaintiff need make only a prima facie showing that jurisdiction exists. Hoffritz for Cutlery Inc. versus Amajack Limited. Under this standard, a plaintiff must plead facts which, if true, are sufficient in themselves to establish jurisdiction as to each defendant. Balestra versus ATB Coin LLC, and to each claim asserted. Sunward Alex Inc. versus McDonald. A plaintiff can make this showing through his own affidavits and supporting materials containing an averment of facts that, if credited, would suffice to establish jurisdiction over the defendant. Whitaker v. American, Telecasting Incorporated. Further, the plaintiff may make a prima facie showing notwithstanding a controverting presentation by the moving party, because all pleadings and affidavits are construed in the light most favorable to the plaintiff, and because where doubts exist, they are resolved in the plaintiff's favor. Hoffritz.
2. Rule 12b6.
Federal Rule of Civil Procedure 12b6 provides for dismissal of a complaint that fails to state a claim upon which relief can be granted. To survive dismissal, a complaint must state a claim that is plausible on its face by alleging sufficient facts for the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Ashcroft versus Iqbal. A court must dismiss a claim if the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct. Although courts will not credit conclusory statements or threadbare recitals of the elements of a cause of action, the court must accept as true all material allegations and draw all reasonable inferences in the plaintiff's favor. Johnson v. Priceline.com, Incorporated. In considering a motion to dismiss for failure to state a claim pursuant to Rule 12b6, a district court may consider the facts alleged in the complaint, documents attached to the complaint as exhibits, and documents incorporated by reference in the complaint. DeFalco v. MSNBC Cable, LLC.
Discussion. 1. Personal jurisdiction.
Hart first asserts that the SEC has failed to establish personal jurisdiction as to any of its claims. To establish personal jurisdiction over a defendant, due process requires a plaintiff to allege 1. That a defendant has certain minimum contacts with the relevant forum, and 2. That the exercise of jurisdiction is reasonable in the circumstances. In re-terrorist attacks on September 11, 2001, CEG, International Shoe Company versus Washington. For purposes of the minimum contacts analysis, the SEC only asserts that I have specific jurisdiction over Hart. Specific jurisdiction exists when a court exercises personal jurisdiction over a defendant in a suit arising out of or related to the defendant's contact with the forum. In Platinum and Palladium antitrust litigation, in determining whether specific jurisdiction exists, courts must assess the quality and nature of the defendant's contacts with the forum state under a totality of the circumstances test. Best Van Lines Inc. v. Walker, quoting Burger King Corporation versus Rudzewicz. The crucial question is whether the defendant has purposefully availed itself of the privilege of conducting activities within the forum state, thus invoking the benefits and protections of its laws, such that the defendant should reasonably anticipate being hailed into court there. Section 77 VA of the Securities Act and Section 78 AA of the Exchange Act, which together govern all causes of action in the complaint, authorize nationwide service of process, meaning that courts look to contacts with the entire United States rather than with the forum state when determining whether to exercise personal jurisdiction over defendants. SEC v. Stubos. CEG Balestra, analyzing defendants' contacts with the United States when determining personal jurisdiction for claims arising under the Securities Act. SEC versus Sheriff, same for the Exchange Act. In determining which contacts to consider, the guiding principle of the minimum contacts test is whether the suit relates to the defendant's contacts with the forum. CFTC v. TFS-ICAP LLC, quoting SEC v. Straub. See also Steele v. United States. Courts must examine the defendant's contacts with the forum at the time of the events underlying the dispute when determining whether they have jurisdiction. The SEC then must show some sort of causal relationship between Hart's U.S. contacts and the episode in suit, and the SEC's claim must in some way arise from Hart's purposeful contacts with the forum. Charles Schwab Corporation versus Bank of America Corp., because the SEC must establish this court's jurisdiction with respect to its unregistered securities claims and its PulseChain fraud claims. I address each set of claims in turn.
A. Unregistered securities claims.
In support of its unregistered securities claims, the SEC relies on contacts that occurred before, during, and after the offer periods. I will first consider Hart's contention that the SEC's alleged post-offer period contacts are not relevant to the inquiry.
Post-offer period contacts.
Hart argues that his virtual attendance at the HEX conference, PulseCon, and his in-person appearance at the Miami interview are irrelevant because investors could no longer participate in the alleged offer and sale of Hart's crypto assets. The SEC argues generally that Hart's mix of online plus in-person promotions together were specifically directed towards the United States and thus constitute sufficient minimum contacts, but fails to adequately address the timing issue raised by Hart. Here, the relevant suit-related conduct is the conduct that could have subjected Hart to liability under Sections 5A, sale of unregistered securities, and 5C, offer of unregistered securities, of the Securities Act for registration violations, Waldman v. Palestine Liberation Organization. Contacts that postdate the offer periods could not subject Hart to liability because investors could no longer purchase Hart's crypto assets pursuant to the offer. See Sarkeesian v. Open Locker Holdings, Inc., finding no personal jurisdiction where the only alleged contacts with the forum did not occur during the events giving rise to liability. For Hex, the offer period closed in November 2020, well before the conferences took place. Although Hart did discuss Hex extensively during the Hex conference, it is irrelevant to the offer and sale of unregistered securities because investors could no longer participate in the offer period. The complaint alleges that since the Hex offering closed, Hex investors can only purchase Hex tokens from third parties on platforms such as Uniswap, but Hart is not alleged to have any control or involvement in Uniswap. Regarding PulseChain and PulseX, although the Hex conference took place before the end of the unofficially extended offer periods for PulseChain and PulseX, nothing was said of significance that related to those offerings. Hart only mentioned PulseChain and PulseX as having a product-market fit, with a lot of traction, a lot of demand. The Hex conference instead focused on Hex's post-offer performance. Without more, Hart's presence at a virtual conference focused on a different post-offering asset is insufficient to establish personal jurisdiction. The remaining alleged contacts, PulseCon and the Miami interview, took place after the PulseChain and PulseX offer periods ended. Moreover, there is no allegation that Hart received investor deposits after the Hex, PulseChain, and PulseX offer periods closed. Absent such allegations, Hart's suit-related conduct does not arise out of or relate to his post-offer period contacts. C7 West 57th Street, Realty Company, LLCV Citigroup Incorporated, finding no personal jurisdiction where the plaintiff has not pled facts, suggesting that the defendant's conduct took place within the relevant time period. Callahan versus Wisdom, refusing to consider certain forum contacts because they were unrelated to the instant suit. Accordingly, I find that Hart's participation in the virtual conferences and his in-person interview are not relevant contacts that could subject Hart to liability for the alleged offer and sale of Hart's crypto assets.
Contacts before and during the offer period.
For the relevant periods, the SEC relies on Hart's online marketing efforts through social media and his websites. Because this conduct occurred outside of the United States, courts employ the effects test, which permits a court to assert specific personal jurisdiction over a defendant if the defendant expressly aimed its conduct at the forum. Dennis v. J.P. Morgan Chase and Company, quoting Leachy ex Arielers Leachy vs. Lebanese Canadian Bank. Incidental effects or even foreseeable effects are insufficient. Instead, the defendant must have intentionally caused, i.e., expressly aimed to cause, an effect in the forum through his conduct elsewhere. 7 West 57th Street Realty Company, LLC.
1. Hart's Internet contacts.
The SEC alleges that Hart extensively marketed Hart's crypto assets on his websites and social media. Hart counters that his online efforts to market and promote Hart's crypto assets were globally available and not expressly directed towards the United States. For the reasons stated below, the remaining suit-related Internet contacts, even considered collectively, are insufficient to establish personal jurisdiction. When determining whether to exercise personal jurisdiction over a defendant because of activity on his website, the Second Circuit considers as a relevant factor a website's interactivity in determining whether the defendant, through the website, purposefully availed himself of the privilege of conducting activities in the forum. Best Van Lines, Inc. A website's degree of interactivity exists on a spectrum, citing Zippo Manufacturing Co. v. Zippo.com, Inc. At one end of the spectrum are active websites, sites where a defendant clearly does business over the Internet because he contracts with residents of a foreign jurisdiction through knowing and repeated Internet communications. Zippo. On the other end are passive websites which do not confer jurisdiction. Passive websites generally do not give users any ability to directly purchase the services through the website. a WLI Group Inc. v. Amber Freight Shipping Lines. Most courts have found that the maintenance of a website alone, without more, does not rise to the level of purposeful availment of a forum's laws. Finally, the middle of the spectrum involves interactive sites, which permit the exchange of information between users in another state and the defendant, which, depending on the level and nature of the exchange, may be a basis for jurisdiction. Citigroup Incorporated versus Citi Holding Company. The SEC argues that Hart conducted business over the internet through his websites and social media campaigns, but the facts as alleged fail to support that position. In making this argument, the SEC relies on my decision in SEC v. PlexCorp, but that reliance is misplaced. In PlexCorp, the SEC brought suit against the defendants for violations of federal securities laws for promoting and selling their crypto asset to U.S. based customers. I rejected the defendants' motion to dismiss for lack of personal jurisdiction because the defendants created several significant internet contacts with the United States while promoting their initial coin offering, or ICO. The defendants used Facebook to directly message information about the ICO to U.S.-based customers, respond to questions, and provide links to the defendants' websites. The defendants also facilitated sales on their websites through payment portals through which users could provide their credit card information and purchase the crypto asset. In part because the defendants' website contacts evinced that they clearly did business over the internet, I determined that personal jurisdiction was proper. In addition to the defendants' website contacts, I determined in PlexCorp that the defendants' trip to the United States to promote the ICO and numerous accounts with U.S.-based payment servicers to facilitate sales constituted significant contacts in support of exercising personal jurisdiction. At oral argument, the SEC rightly acknowledged that it did not have all the contacts that existed in PlexCorp. Here, unlike in PlexCorp, Hart's website contacts were not active. The complaint fails to allege that Hart facilitated transactions, collected credit card information, or entered into contracts with U.S.-based investors through his websites. Therefore, Hart did not clearly do business over his websites. Zippo, nor do Hart's website contacts fall towards the middle of the spectrum. The complaint alleges that Hart provided information via YouTube and on his website on how users could invest in Hart's crypto assets. However, Hart did not directly message U.S.-based investors or respond to questions through his websites. Rather, Hart disseminated how-to information, which alone is not sufficient. Hart's website contacts instead fall closer to the passive end of the Zippo spectrum. As alleged, Hart's websites included clickable tabs that provided information on how to purchase Hart's crypto assets, but simply posting information on an internet website, which is accessible to users in foreign jurisdictions, is not grounds for the exercise of personal jurisdiction. The SEC's reliance on ethhex.com is also misplaced. The SEC argues that Hart directly facilitated sales through designing ethhex.com, a website interface that allows investors to engage in secondary market transactions through Uniswap. However, ethhex.com does not sell Hex. Instead, it provides a link to a third-party platform wherein users can swap tokens directly with other users, which is insufficient to support exercising personal jurisdiction. See Novak v. Overture Serves, Inc. Finding that a website that sells no goods but provides links to other sites that sell goods does not provide grounds for personal jurisdiction. What is more, the complaint fails to allege that any U.S. investor used ethhex.com to purchase Hex through the secondary market. See Royalty Network Inc. v. Deshant.com, LLC, finding it unnecessary to reach the jurisdictional question regarding the defendant's transaction of business where the plaintiff provided no evidence that any forum resident actually engaged in any such transactions through the defendant's website. Best Van Lines, quoting Zippo, C., e.g. Atwal v. iFinex Inc., defendants did not purposefully avail themselves of the privilege of conducting business in the forum simply because a forum resident submitted a support ticket on their website and briefly communicated with a representative. Safex Foundation, Inc. v. Safe Launch Ventures Limited. Finding the accessibility of a foreign cryptocurrency company defendant's website and some of its interactive features, including a clickable link to a third-party cryptocurrency exchange, insufficient to support a finding of personal jurisdiction under the D.C. long-arm statute. Accordingly, Hart's website contacts simply provided globally available information and lacked sufficient interactivity to constitute a significant contact. Hart's social media statements fare no better. Hart claimed on YouTube that Hex was built to outperform Ethereum and Bitcoin and all other cryptocurrencies, but such statements are not alleged to be expressly targeted at the United States any more than at other forums. See 79th Group Inc. v. Moore. Finding that a social media post accessible to forum residents but not expressly targeted at them could not establish personal jurisdiction. CF Hardin v. Tron Foundation. Finding that the defendant's social media statement, "If your friends ask you where is the best exchange to buy TRX in United States and Europe, the best answer is at Kraken FX," targeted the U.S. market. In sum, the relevant online communications described in the complaint during the offer periods consist of untargeted, globally available information. The SEC failed to plead sufficient facts to suggest that Hart's online statements were purposefully directed to the forum, rather than a global audience. Best Van Lines.
2. U.S. Based Developer.
The SEC argues half-heartedly that Hart's involvement with Bar, a software developer, to develop Hart's crypto assets constitutes purposeful conduct directed at the United States. At oral argument, the SEC acknowledged that Bar was not one of our principal contacts we're relying on. For the reasons discussed below, Bar's involvement with Hart falls short of what is necessary to exercise personal jurisdiction over Hart. First, there is no allegation that Bar was in the United States while he worked with Hart. The affidavit says only that Bar currently lives in the United States. Further, the SEC admits that there was nothing to suggest that Mr. Hart knew that he was dealing with somebody in the United States when he was engaging him for work on Hex and PulseChain. Even if Bar were in the United States, he was not an employee of Hart. Instead, he was only a volunteer, and his activities were purely incidental to his presence in the forum. See Outdoor Partners LLC vs. Rabbit Hole Interactive Corporation. Finding that a defendant who did nothing more than to contract with a forum resident who tested and debugged defendants' games in the forum did not have minimum contacts with the forum. Callahan, finding that merely engaging a consultant who purely incidental to his work for the defendant was located in the forum did not establish personal jurisdiction. Further, Bar's activities are not alleged to relate to efforts to market and promote the alleged securities at issue. Compare SECV Terraform Labs, Private Limited, affirming a finding of personal jurisdiction where the defendant retained U.S. based employees that were directly involved in promoting the digital assets at issue. Because Hart did not engage in substantial suit-related conduct in or directed at the United States in connection with the offer and sale of Hart's crypto assets, I find that Hart does not have sufficient contacts with the United States for specific jurisdiction. See Walden v. Fiore. The defendant's suit-related conduct must create a substantial connection with the forum state. Since I conclude that minimum contacts are lacking, I need not determine whether exercising personal jurisdiction over Hart for the unregistered securities claims would satisfy the Fifth Amendment's reasonableness requirement. See in Re Hang Holdings Limited Securities Litigation.
B. PulseChain fraud claims.
I further find that there is no personal jurisdiction over Hart for the PulseChain fraud claims, as discussed above, because the relevant conduct for Hart's alleged fraudulent conduct occurred entirely out of forum. The Second Circuit relies on the effects test. Pursuant to the effects test, personal jurisdiction is proper if Hart expressly aimed his conduct at the forum. The SEC fails to meet this test. The SEC's allegations of Hart's misuse of investor funds and material omissions all occurred abroad. Hart's alleged deceptive acts include misappropriating investor funds between August 2021 and September 2022 and using devices to conceal the funds' movement. To the extent the complaint shows that Hart misappropriated investor funds through deceptive mixer transactions, those actions occurred entirely outside of the United States. The alleged misappropriation occurred through digital wallets and crypto asset platforms, none of which were alleged to have any connection with the United States. See in Aegean Marine Petroleum Network, Inc. Finding that the defendant did not direct his conduct toward the United States because, to the extent that the complaint establishes that the defendant embezzled funds, those actions were entirely outside of the United States. The SEC alleges that Hart's material omissions included telling investors about PulseChain's development progress and that their investments supported free speech ideals while failing to disclose his luxury purchases. As an initial matter, although the timeline for the PulseChain fraud claims encompasses Hart's attendance at the virtual conferences and his in-person interview in Miami, the SEC does not allege that these events relate in any way to the conduct underlying its fraud claims. The SEC conceded that it was not using any of the conferences as a part of its fraud claims. What remains are online statements wherein Hart allegedly spoke about the use of PulseChain investor funds to develop the blockchain. As discussed above, globally available internet content not expressly directed at the United States is insufficient to establish minimum contacts. See Best Van Lines. Accordingly, a focus on the relationship of Hart, the forum, and Hart's suit-related conduct points to the conclusion that there is no specific personal jurisdiction over Hart for the PulseChain fraud claims in this case. The SEC also raised, for the first time at oral argument, that because Hart talked about the tests set forth in SEC v. W.J. Howie Company, his online conduct was directed towards U.S. investors. However, federal district courts generally reject arguments raised for the first time at oral argument. NNV Mayorkas, see United States v. Barnes. Normally, the court will not consider arguments raised for the first time in a reply brief, let alone at or after oral argument, quoting Keefe v. Shalala. In any event, it is unclear whether the allegations in the complaint support the SEC's new argument. The complaint only alleges that Hart is familiar with the Howie test, but does not allege specific statements tracking Howie's language directed towards U.S. investors.
2. Application of the United States securities laws.
Even if the SEC had established personal jurisdiction over Hart, the complaint cannot stand because it fails to adequately plead that either the transactions or conduct at issue were domestic under the federal securities laws.
A. Section 5A, Sales of Securities Claim.
It is a long-standing principle of American law that legislation of Congress, unless a contrary intent appears, is meant to apply only within the territorial jurisdiction of the United States. Morrison v. National Australia Bank Limited. The SEC alleges that Hart sold securities without filing a registration statement in violation of 15 U.S.C. Section 77 EA. In Morrison, the court determined that the Exchange Act applied to 1. Securities listed on domestic exchanges, and 2. Domestic transactions in other securities. The Morrison framework also applies to Securities Act claims, Williams v. Binance. A plaintiff, therefore, must show that transactions at issue were either listed on domestic exchanges or that the purchase or sale occurred in the United States. Harden. Hart's crypto assets did not trade on domestic exchanges. Thus, the relevant inquiry is limited to the second prong, whether the SEC has alleged domestic transactions in crypto assets. To establish the existence of a domestic securities transaction in securities not listed on a domestic exchange, a plaintiff must allege facts suggesting that irrevocable liability was incurred or title was transferred within the United States. Absolute Activist Value Master Fund, Limited versus Ficeto. Irrevocable liability can be used to determine the locus of a securities purchase or sale. Parties may become irrevocably bound if there was a meeting of the minds. Factual allegations, including but not limited to facts concerning the formation of the contracts, the placement of purchase orders, the passing of title, or the exchange of money in the United States may be sufficient to show that parties became irrevocably bound within the United States. But merely asserting in conclusory fashion that transactions took place in the United States is insufficient to adequately plead the existence of domestic transactions. Hart contends that the federal securities laws do not apply to the sale of Hart's crypto assets because the complaint merely alleges that an unspecified number of U.S.-based investors participated in the offerings. The SEC argues that irrevocable liability attached when U.S.-based investors deposited crypto assets into digital wallets located on the blockchain in exchange for Hart's crypto assets. In support of its position, the SEC relies on the Second Circuit's recent decision in Williams v. Binance, which addressed the extraterritorial application of securities law under Morrison to transactions in crypto assets. In Williams, the court held that the plaintiffs had plausibly alleged that their securities law claims involved domestic transactions for the purposes of Morrison. There, the plaintiffs were U.S. based purchasers of crypto assets on defendant Binance's digital asset exchange. The plaintiffs alleged that while in the United States, they registered accounts with Binance, accepted Binance's terms of use, and placed buy orders which were matched on Binance's servers, the majority of which were in the United States. Pursuant to the terms of use, once the trades were matched, they could not be canceled. Further, Binance disclaimed having any physical location or being subject to any country's securities regulation regime. Binance did, however, have a substantial presence, with servers, employees, and customers throughout the United States. The court acknowledged that determining where irrevocable liability attaches is particularly difficult when a transaction takes place over an exchange that claims to have no physical location in any geographic jurisdiction and not be subject to the oversight of any country's regulatory authority. Despite this difficulty, the court noted that transactions on such a digital exchange cannot occur nowhere. The court determined that two transactional steps gave rise to an inference that irrevocable liability occurred in the United States. Under the first transactional step, the court found it was appropriate to determine where matching occurred solely based on the location of the servers because Binance had not registered in any country, purported to have no physical or official location whatsoever, and the authorities in Malta, where its nominal headquarters are located, disclaimed responsibility for regulating Binance. The court distinguished cases involving trades executed over a foreign exchange because the application of United States securities law here does not risk incompatibility with the applicable laws of other countries. The court held that the first transactional step occurred when the transactions at issue were matched and therefore became irrevocable on servers located in the United States. The court next determined that the transactions were domestic for a second interrelated reason. The court explained that in the context of transactions not on a foreign exchange, our cases look to facts concerning the formation of the contracts, the placement of purchase orders, the passing of title, or the exchange of money to determine when and where an investor becomes irrevocably bound to complete a transaction. In considering these factors, the court concluded that irrevocable liability attached when the plaintiffs entered into the terms of use with Binance, placed their trade orders, and sent payments, all of which they claim occurred from their home states within the United States. In a prior case, the Second Circuit held that the mere placement of a buy order in the United States for the purchase of foreign securities on a foreign exchange was not, standing alone, sufficient to allege that a purchaser incurred irrevocable liability in the United States. Quoting City of Pontiac Policemen's and Firemen's Retirees, CISB v. UBSAG. The Williams Court distinguished City of Pontiac because the plaintiffs in Williams made domestic payments pursuant to Binance's terms of use, which rendered their agreements to purchase crypto assets binding, and because of the lack of sovereignty and comity concerns, where no country claimed its regulatory regime applied. Here, unlike in Williams, the complaint fails to allege that investors' deposits were matched on servers in the United States. The Williams Court also relied on Binance's substantial presence in the United States, including servers, employees, and customers, to find that matching plausibly occurred on Binance's U.S. based infrastructure. Here, as alleged, Hart does not have a presence, let alone a substantial one, in any way comparable to Binance. Nor does the complaint allege that the deposits were first validated on the blockchain in the United States. Compare Williams v. Block 1, noting that, in general, irrevocable liability is incurred when the transaction has been verified by at least one individual node of the blockchain. Thus, the complaint fails to satisfy the first transactional step under Williams. The SEC interprets Williams, however, to stand for the proposition that sending buy orders and payments from the United States is a second separate basis to establish irrevocable liability. Therefore, under this standalone basis, irrevocable liability occurred in the United States when U.S. based investors deposited crypto assets into digital wallets on the blockchain. In response, Hart argues that the Second Circuit expressly observed that placing purchase orders from the United States was only a second, interrelated reason to find that irrevocable liability attached in the United States, citing Williams. Whether it is or is not an independent basis to show that the parties became irrevocably bound within the United States, there are insufficient allegations to apply this basis. First, the Second Circuit specifically expressed that we have reason here to consider where the trades originated because Binance expressly disclaims having any physical location, and therefore the sovereignty and comity concerns are less present. Williams, CSECV Binance Holdings Limited, explaining that because Binance disclaimed having any location or being subject to any other particular jurisdiction, the Williams court rejected its argument that the plaintiff's transactions were not domestic. Here, Hart made no such disclaimers. Rather, the complaint alleges that Hart is a resident of Finland. Unlike Malta's express disclaimer of regulatory responsibility over Binance, Finland is not alleged to have made any such disclaimer. Further, the SEC attempts to assert in conclusory fashion that the transactions took place in the United States. The investors did not enter into terms of use with Hart. Instead, the SEC relies on allegations that investors deposited crypto assets into digital wallets, including from investors in the United States, which is insufficient. Cf. Messier v. HDR Globe Trading Limited, finding irrevocable liability incurred in the United States because customers entered into terms of use agreements, purchased the tokens from within the United States, and the defendant's employees liquidated the plaintiff's crypto holdings from within the United States. Courts have required far more U.S.-centric allegations to show that the crypto asset transactions at issue were sufficiently domestic. In Barron v. Helbiz Incorporated, the court found that the alleged transactions were domestic because the digital wallets that generated crypto assets for U.S.-based investors were controlled by a U.S. resident and operated out of the United States, and the defendants were in the United States when they sold their own crypto assets to the public. In Retezo Securities litigation, the court determined the alleged transactions were domestic because users participated in the transactions from the United States through an interactive website hosted in the United States and operated by a U.S. resident, and the transaction was validated by a network of global nodes clustered more densely in the United States than in any other country. Here, no similar allegations are present. Instead, the SEC's allegations fall short of adequately pleading a domestic transaction. I acknowledge the Second Circuit's concern that transactions on a digital exchange cannot occur nowhere, but as alleged, I cannot reasonably infer that these transactions occurred in the United States. Accordingly, the SEC has failed to adequately allege domestic transactions for its Section 5A claims.
B. Section 5C offers of securities claims.
Section 5C prohibits offering a security without a registration statement. 15 U.S.C. Section 77 EC. The parties disagree about what test I should apply to determine whether Hart's alleged offer of Hart's crypto assets without a registration statement was domestic. Hart argues that the relevant consideration is the location of the offerer. The SEC claims that it is what the offerees heard while in the United States that should control, and because Hart engaged in conduct, albeit abroad, that targeted U.S. investors, there is sufficient domestic conduct to apply U.S. securities laws. Courts in this district have determined that for an offer to be domestic under the Securities Act, a person or entity must, 1. Attempt or offer in the United States to dispose of securities, or 2. Solicit in the United States an offer to buy securities. SECV Goldman Sachs and Company, SECV Ripple Labs, Incorporated. It is the location of the offerers that is relevant. Here, the complaint does not allege that Hart attempted to offer securities during the relevant offer periods while in the United States. Compare Ripple, finding that the defendants made domestic offers because the defendants resided in the United States when they directed their offers of crypto assets. Accordingly, I find that the SEC has failed to show that Hart made domestic offers of Hart's crypto assets. The SEC relies on SEC versus Bellina, motion to certify appeal granted. There, the court held that the defendant made a domestic offer of his crypto asset from outside the United States through extensive marketing efforts on social media platforms. Aside from being an out-of-circuit decision, the facts in Bellina are not present here. Unlike here, the defendant was a U.S. resident who traveled abroad for 2 months while he promoted an ICO through social media, including to a pool of investors known to reside in the United States. The court also discussed public policy concerns that counseled against encouraging others to temporarily leave the United States to evade United States securities regulations while targeting United States investors. The complaint is devoid of similar allegations or public policy concerns that warrant following Bellina.
C. PulseChain fraud claims.
The SEC asserts its PulseChain fraud claims under Section 10B of the Exchange Act and under Section 17A of the Securities Act. The parties dispute which test governs these claims. The SEC argues that Congress, through the Dodd-Frank Wall Street Reform and Consumer Protection Act, Dodd-Frank, overrode Morrison's transactional test and reinstated the previously applied conduct and effects test for SEC anti-fraud actions. Hart argues that Morrison's transactional test governs because Dodd-Frank's plain language does not rebut the presumption against extraterritoriality, and also because the Second Circuit explicitly questioned of the impact of Dodd-Frank on Morrison, citing Park Central Globe, Hub Limited versus Porsche Auto, Holdings SE. I need not determine which test should govern because the SEC has failed to state a claim for its PulseChain fraud claims under either inquiry. Under Morrison, the SEC again fails to sufficiently allege that participants in the PulseChain offering became irrevocably bound in the United States. As discussed above, allegations that crypto assets were deposited into digital wallets on the blockchain by an unknown number of U.S. investors is insufficient. To satisfy the conduct and effects test, the SEC must show 1. Conduct within the United States that constitutes significant steps in furtherance of the violation, or 2. Conduct occurring outside the United States that has a foreseeable substantial effect within the United States. 15 U.S.C. Section 77 V.C., 15 U.S.C. Section 78 A.a.b. Here, the SEC fails to allege sufficient facts that place Hart's conduct within the United States. For example, the SEC alleges that Hart discussed the benefits of PulseChain, its profit potential, and his development efforts on PulseChain's website and YouTube. Notably, the complaint fails to allege that this conduct was directed at the United States. Instead, it merely alleges this conduct originated abroad through online activities. See Cornwell v. Credit Suisse Group. Finding alleged misrepresentations and omissions that originated abroad did not satisfy the conduct test. As such, I cannot reasonably infer that Hart's conduct was conduct within the United States. 15 U.S.C. Section 77 VEEC, 15 U.S.C. Section 78 AAAB, CF, SECV Scoville. Finding the defendants engaged in conduct within the United States in furtherance of their fraud because the defendants created and promoted investments while residing in the United States through their website, which was housed on servers located in the United States. The SEC also fails to satisfy the effects test. The complaint alleges that some investors in the U.S. deposited crypto assets during the PulseChain offer period. This fails to show that the alleged fraud had a substantial effect in the United States. 15 U.S.C. Section 77 V.C., 15 U.S.C. Section 78 AAB, C. Cornwell. The court has no information regarding the percentage of the defendants' shares that were owned by United States investors, and therefore cannot find that the fraud would have had a substantial effect in the United States or upon United States citizens. F. Consul Nar. Goldfields, PLCV Minorco. Finding the effects test satisfied, where American residents representing 2.5% of Goldfields shareholders owned 5.3 million shares with a market value of about $120 million. In Rescore Holdings, Switzerland, AG Ledig. Given such broad U.S. holdings, between 14% and 29%, it must be concluded at this stage that the alleged fraud, even if it occurred entirely outside the United States, would have had a substantial effect in the United States or upon United States citizens. For the reasons discussed above, I find that the SEC has failed to state a claim for its PulseChain fraud claims.
3. Leave to amend.
The SEC asks that should I grant Hart's motion, I grant the SEC leave to amend the complaint. The court should freely give leave to amend when justice so requires. This is a liberal and permissive standard that is consistent with our strong preference for resolving disputes on the merits. Loreley Finance, Jersey, Number 3, Limited versus Wells Fargo Securities, LLC. If the SEC believes in good faith that it can amend the complaint to remedy the deficiencies identified herein, any such amended complaint must be filed within 20 days of the date of this order. For the reasons set forth, Hart's motion to dismiss is granted. So ordered.
Dated February 28, 2025, Brooklyn, New York. Signed, Carol Bagley Amon, United States District Judge. March 14, 2025, via ECF, Securities and Exchange Commission v. Schueler.
Dear Judge Amon, Plaintiff Securities and Exchange Commission, SEC, or the Commission, submits this request for an extension of time and respectfully states the following. On February 28, 2025, the Court dismissed the complaint in this matter, directing the SEC to file an amended complaint, if any, within 20 days of the order. Accordingly, an amended complaint must be filed by March 20, 2025. The Commission requests a 30-day extension of this deadline for several reasons. First, the staff of the Commission is in the process of reviewing the Court's order and re-evaluating the evidence obtained, both during its investigation and since filing the complaint, to determine whether filing an amended complaint is warranted. Second, because of the structure of the Commission, which includes enforcement staff making recommendations to appointed commissioners and the acting chair, this process requires more time than a determination involving a typical litigant. Accordingly, an additional 30 days will allow time for the Commission to make a determination in response to the Court's order. Finally, counsel for defendant Richard Hart has requested to meet with the Commission's front office staff to discuss whether the Commission should file an amended complaint. An extension of time would give the staff of the Commission more options in considering how to accommodate Hart's request. The Court's individual motion practices and rules require that all requests for extensions of time must state 1. The original date, March 20, 2025. 2. The number of previous requests for extension, 0. 3. Whether previous requests were granted or denied, not applicable. And 4. The adversary's position, with reasons if opposed, reasons as follows. Upon consultation, defendant Hart states,
Richard Hart respectfully opposes the SEC's request for an extension of time to amend the complaint in this action. The SEC cannot remedy the myriad, long-known deficiencies in its complaint, and it deserves no more time than the Court has already afforded it. The SEC has known about the precise legal deficiencies for which this Court dismissed the complaint for well over a year. Nothing supports the SEC's suggestion that the defects can be cured, nor that another 30 days will make a difference. The SEC has had 430 days since Mr. Hart's pre-motion letter and 340 days since his motion to dismiss to determine how to cure the deficiencies that Mr. Hart identified long ago in the event of an adverse ruling. That should have been more than enough time for the SEC to formulate a strategy for amendment. That the SEC cannot fix its complaint within the 20 days granted by the Court just further reveals that the complaint is beyond repair. In its opposition brief, the SEC admitted that it was unable to cite with specificity those amendments it could make at this time. The SEC's July 22, 2024 deadline to amend its complaint came and went without event. Of particular note, the SEC fell short, despite including in its previous filings 2 additional declarations comprising over 70 paragraphs of additional allegations, and 74 pages total of evidence outside of its complaint. This Court ordered that the SEC may only amend its complaint if it believes in good faith that the amendment will remedy the deficiencies identified in the opinion. If the SEC had any such good faith basis to amend, there is no reason that it should need more time than what the Court already provided.
The SEC requests an additional 30 days within which to file an amended complaint in this matter, making the new complaint due on April 21, 2025. This request is made in the interest of efficient resolution of this matter and not for the purpose of unreasonable delay.
Dated March 14, 2025. Respectfully submitted, Matthew J. Gould, U.S. Securities and Exchange Commission, Fort Worth Regional Office.